Hello, and we're back at part 3. Let's get back to the courtroom here. Sir, I just asked you the question, have you seen any lawyers in here who didn't know when and how to file with this court a motion of any kind? Have you seen that while we were in here? Well, Your Honor, I don't know if that, sir, you're going to answer that question or you're going to go to jail. I don't know what your answer is, but you're going to answer it and not turn it into your game show. And they have to either say, no, Your Honor, I haven't seen any attorney who didn't know how to file a motion. And you go from there and you say, well, in that case, it's up to you to either learn how to do it, or if you want, you can explain to the court that you've tried to make yourself intelligent enough to represent yourself. Not intelligent, how about well-educated enough to represent yourself, and it's just way too massive of an undergoing, and so therefore you do want to have counsel. Or, up to you. If you say, no, I did see a lawyer who didn't know how to file a motion, and you could ask him what lawyer that was. He'll say he doesn't know. But what I'm trying to do is to get him to admit that the other lawyers, that he does know and does see that the other lawyers in the courtroom do not make the same type of stupid mistakes he does. And that if they are not making those mistakes before the court, he should not be making those mistakes before the court. And therefore, the answer to his question where he says, well, Judge, I don't give you advice. I'm not your attorney. Your attorney answers those questions for you. If you want to be your own attorney, you'll have to answer those questions to yourself. That's obviously a horrible idea, but that's the one that you've taken on. So there will be no advice coming from here, but what we were talking about was, can you use that pitch for, Your Honor, I need to know, can you use that delay tactic in order to not answer the questions that are up before you, especially if they're from the court. But this also applies, by the way, if you're on the stand. So if the judge then says to you, sir, what name do you wish to be known by in court? There is no question, despite what your packet says or your book says, there is no question that you are entitled to use to delay or to mislead the court in another direction. There isn't. Your obligation to avoid being in contempt of the court, or a contemner, as we rarely get the chance to say. I love that word, but we rarely get a chance to say it. But to avoid being a contemner, a person who is found in contempt, is to answer the court's question, or if there is, in those rare cases where you can't answer because of X, Y, or Z, to notify the court of that. The intentional launching into these endless chains of, Your Honor, how can I answer the question when I don't know if the court has jurisdiction, are based upon the books falsely quoting the statute about jurisdiction. That's falsely given to you as well, if you're a litigant, not if you're a judge. So you cannot stand there in the courtroom, even though we see it all day, and think you're not going to be hammered by the judge for not responding correctly to the court's inquiry, and I use the court and the judge interchangeably, which you're allowed to do. If the judge asks you, sir, what is your best estimate as to when your paper can be served upon the prosecution? If you stand up and Your Honor, There's no way I can know that. I have to go through that is evading the court's question. And since the court asked you for your best estimate, not the estimate, all of the excuses you give as to why it's not easy for you to calculate when the papers are ready are BS. They are not in compliance with the court's question, and he could hold you in contempt right then and there. He didn't say you had to be 100% accurate. What he said was, based on what you have, what's your best estimate? And if your best estimate is, I don't know, maybe a week from now, okay, that's your best estimate. That would comply with the court's order. But you cannot interrupt the court's inquiry to you and go into a questioning back of the judge. Now, I understand we just heard that. We just heard a lot of it. But that just means that judge doesn't know what he is doing. Maybe he's a new judge. Maybe it's his first day. I remember the first night I did night court. And somehow a case got thrown in there that shouldn't have been in there. Oh, my God. And I didn't know what to do. And I actually got down off the bench and went into the courtroom next door, but I forgot to take my black robe off. You're never supposed to go into another courtroom when the judge is up there and you wearing a black robe. That's like terrible. Nobody said anything. I never got in trouble for it, but you never do that. But I didn't know what the hell I was supposed to do. It was people in the middle of a divorce fighting over the money they're paying experts to testify in the divorce, and then bringing that issue into the small claims court. Whoa. Okay, that was like a lawsuit exam, you know? So, let's get back to those people standing up in court thinking they have the right to, when asked by the court a question, to dick the court around. Excuse me for using that expression, but that's the only one I can think of. What in the world do you think you're going to accomplish by giving the court I keep asking them questions that relate to religion or jurisdiction? What do you think you're going to accomplish? So let's go first to the jurisdictional issue. I want to make sure you understand that every time you go up there, if you read the language that supposedly supports your ability to not participate in the court in any way, that segment is misquoted from the Constitution. Or it might be from a case, I'll find out. But it's not the correct quote. It is not. Well, I wish I had a chorus here, like 1,000 people. Not your right to challenge jurisdiction at any time. It's your right to challenge jurisdiction if there is a reasonable basis to believe that the court doesn't have jurisdiction. But the fact that you don't like being in court and you're looking for a clever way to card up your sleeve to get out, that is not a basis for challenging jurisdiction. No, you do not have the right to challenge jurisdiction anytime you want. No, the problem that you do not understand how jurisdiction works is not the fault of the court. It entitles you to no relief. It is resolved by either you go to law school and you take the year course called civil procedure, and then you hire an attorney anyway. That's how you get around the fact that you don't understand the jurisdiction. But no, anybody who has that false idea that they get from that packet of documents just challenge jurisdiction and read the paragraph that says you have the right to challenge jurisdiction and the court doesn't have the right to go ahead until they've resolved it. Any lawyer knows that you're being ridiculous, because if that were true, the way you read it, who would they prove it to? Who are you saying the court has to convince that they have jurisdiction? You? So now you think that you're the judge and jury and the court is the litigant having to prove to you that the court has jurisdiction? Are they supposed to file motions in your court? It's absurd. And it has to be cut off at the ankles. The minute somebody raises that, if they've been warned previously, they're sanctioned the first time they bring it up. If they have not been warned previously, they're given the explanation that I just began, and believe me, it's got about 50 more paragraphs to go. And then you explain to them, my understanding is you probably want to withdraw this challenge to jurisdiction. And if you want to be a really good, fair player, you can say, I'm not saying you cannot make a challenge, because that is what they'll say no matter what. Sir, are you saying I cannot challenge jurisdiction in your court? I don't have the right. It's my blah, 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 blah. And you say, sir, I just told you, don't argue the case. I don't care what you think your rights are. Your rights are not to take over control of the courtroom this morning at 9:21 or whatever time it is on your watch. And you say, your rights are to proceed with the trial. And if you want to file a motion, I did file a motion. When did you file it? I filed it right after Sky Rangers was over. When was that? I guess about 8:15. So you filed it this morning, sir? Is that what you're saying? Not so much. Sir, did you file it this morning? Yeah. Yes. Okay, so then you filed it not in compliance with the court rules, and as such, if you're brave, you can say, I'm throwing it out. If you're not brave, you can say, we'll hand it back to you, and you can refile it and get a date in compliance with the court rules. Well, what are the court rules? Sir, did I call on you? Well, no, but I need to know when, sir. Do you think your need to know means you don't have to be quiet in court? You can talk in court? It does not. You have no right to speak in court unless you signal to the court that you have a question and the court recognizes you and says, go ahead. Only other time would be if you want to object when we're doing testimony. Well, Your Honor, I'll tell you, that doesn't seem very fair to me. I'm trying to just challenge the jury. Okay, you say, okay, I just told you, don't do that. And now you've done it for the third time, and now you're in contempt. So I want to get the case going. But we'll let the jury out at 11:30, and at 11:40 we will have a determination of your contempt and what your sentence is going to be for that contempt, if any. So that's how you nip it in the butt. So you can pass it to the next judge, because, most people don't realize, but most cases do get passed down the line to another judge. They start out, by the way, this is really interesting, they start out at the bottom of the barrel, judge, like me, and as the issues become more serious in their resolution, that means, if the decision of the court is going to affect the person's life, it goes up to a judge who's maybe been deciding these types of matters for 25 years and isn't a part-time judge like I was. So that is the basic rule, but like everything else, it has a flip side as well. Now I want to find my notes here about, it's not just the part-time of standing up and insisting that you have the right to raise the jurisdiction. That is a ridiculous and losing argument. But equally as pointless and time-wasting for the court is the one where you're going to run the court through an exercise and you're not going to tell them your name because you're going to answer every question about your name with a question to the court about, does the court deny that you have the right to have Jesus come to court with you, et cetera, et cetera, et cetera. And the answer to that is not what this judge did, but instead, the first time, he starts to go off about the court filings have a H and a capital H, and you have a little h, and that does the court, I want to see the evidence. You let him know, as this judge did do, that the court doesn't dispense evidence. The court doesn't have evidence. The court doesn't keep evidence. The court doesn't give out evidence. If he wants evidence that he believes is in the possession of the prosecutor, he has to, I know, you've heard it before, he has to file a timely motion. He has to file it in time. He has to give the prosecution time to read it, and hopefully time that they can respond in writing with enough time so that the court can read both papers, and there's still a week till the hearing. So the court can take its time and casually read both papers and look up to see if anybody's fibbing about the law. Now, when I'm in there, if I hit the shepherdization button, is what we used to call it, the button that is the button that looks up the cases to see if they're still valid cases or if they've been overruled or criticized. Then when we go through that, it's a way that if I do find that one side or the other has made a mistake, it is always on the sovereign citizen side. And I can just tell you that's because 2 and maybe 3 of the main stool legs of their argument are not valid. They've been misquoted. And one of them, and you'll hear a DA break the news to poor Eric Martin about this, one of them doesn't even exist. The person just made up their own legal pronouncement by a court, and there was no court and no such pronouncement. Now, because this person has not gone to law school and taken a course on ethics, he doesn't know that is an instant bounce into jail. If a lawyer does that, that's instant bounce into jail. And of course, the first thing this person will offer as an excuse is, well, Your Honor, I'm not a lawyer. I didn't go to law school. And the first thing I'll remind him is, do you remember when I told you that if you wanted to be your own attorney, you would not be allowed to use that as an excuse or justification, and that's why it's such a terrible idea to be your own attorney, that you are certifying before me that you actually have your legal conduct up to that level where you would not make that kind of mistake. Okay? You guaranteed me you would not make that kind of error, and that you had to do that in order for me to grant you your permission to be your own attorney. Okay, if you have been through that colloquy with the sovereign citizen, then bang, if you find the paragraph that's not really a legal paragraph, just send them to jail. Just give them a very brief contempt hearing, maybe 5 minutes of, okay, here's what your paragraph reads. This is your paper, correct? Yes. Did you write the paper? First thing they'll say is, no, I had somebody else write it, but I thought it was, okay. So you didn't check then to see if the citations they wrote were valid. Well, I assume they were. The person is a big author, and so, well, you can't assume. And also, you signed at the end that you wrote this paper. Just look at this. See the last page? See that swear that you are the one who wrote this paper and that you've checked and that all of it's all of its legal citations are valid, that's you, right? You swore to that right there, right? Yes, Your Honor. Well, today is Judgment Day. So you said you would not make that mistake, and you went right out and made that mistake because you were lazy and didn't want to go to maybe the law library or the local law school and find out how do you check the validity. You could probably do it on online now. Probably there's a way to do it without even having to go to the law library if you just join up on one of the services that sells that information. So you could have done it. There's no reason why you could not have gotten the valid warning that your citations are not approved by law. And therefore, in order to stop this kind of hoax you're perpetrating on the court, I'm going to sentence you to 10 days in jail. We'll see you in 10 days, and we'll start right back up from where we left off this morning. And that's how we do it. Now, we'll get into a couple of other problems that arise right at the beginning of the trial, but those are the big ones. I'm getting a little bit of... they are more fun to watch. I'm getting some questions from some of the viewers or listeners or whatever you are. I guess they're listeners. Can we talk about the police arrests? They do come first. That's true. If we were going to do this in a sensible order, we would have gone over the sovereign citizen method of trying to defeat a traffic stop, which, according to the statistics I read, has never worked. I did see one case where the police let the person go with much less than they should have, but they still did ticket them. It was a ticket case. But I was pretty angry because that person deserved a lot more than that. And I was wondering if it was because the dumb cops in the case in the middle of Ponca City, Oklahoma, actually agreed with the sovereign citizen. I think it was. They kept apologizing to the driver about, we're sorry, we agree, we understand this, we agree with you, we understand this, but we still got to do our job. So who cop apologizes for the fact that he has to do his job? If you're sorry that you have to do your job, maybe just go find another job. So, thank you, and we'll talk to you again next Thursday. And depending, I've already constructed what was going to be the next stage in the trial court on how the judges can handle and remove as a impairment or impediment to the court the sovereign citizen. But if I get one more email from a person who says, no, I want to hear how sovereign citizen law is applicable or not applicable. Let's leave it that. We'll make it a suspenseful podcast. How does it apply to the normal everyday stop by a chippy, as we used to call them, as a CHP officer, or a sheriff in a standard traffic citation? Well, it'll be one of those two, but that will be next week. That'll be in August. But today's Thursday, and or maybe if you got a little early, good for you. But next Thursday will either be part 2 of first day of trial, how the judge can handle the obstreperous conduct of the sovereign citizen, or if I'm feeling talkative, we'll just go for the entire ball of wax of the arrest, and is there any validity to the impairments that the person throws in the way of the cop, such as, I'm not giving my license until you get the sergeant. Can you do that? I'll see you next Thursday.